In this video, we're continuing to talk about the concept of actus reus, which is pertaining to and related to the idea of elements of a crime and criminal liability. In this video specifically, we'll talk about this idea of criminal conduct, making distinctions between voluntariness and automatism, making distinctions between acts and omissions as well. These will be useful for our adventures, shall we say, into some of these concepts in more detail in future lessons' time, and to concepts such as things like causation as well. So we're talking in more detail in this lesson about the idea of criminal conduct in relation to the actus reus for a criminal offence. And we're talking firstly about the concept of acts versus omissions. So ultimately, we remember from our previous lesson that the concept of actus reus refers to the idea of a guilty act. The idea here is that in order for you to be held liable under some kind of criminal offence, whether that be a statutory offence or a common law offence, you have to have done a thing or not done a thing such that liability is incurred onto you. You cannot be simply guilty for having a mental state, for having a guilty mind. I can think as much as I like about committing crimes, as long as I don't actually do so with the guilty mind. I'm okay. The police are not going to be able to arrest me for thinking about committing crimes. Instead, you have to have the guilty act. Now, as we mentioned in previous lessons, we know that the actus reus of an offence needs not require the criminal conduct, the thing itself, to be an act. In some cases, and in certain offences, it may even be the case that a serious omission can give rise to criminal liability. So an omission is simply a failure to act. So rather than you doing and performing a positive act, rather than you going and doing a thing, an omission is you failing to do something such that the result leads to something which could give rise to criminal liability. And the standard and the burden that is placed here is a little bit higher than an act itself, given the fact that in certain circumstances you are not held liable for all of your failures to act in a particular circumstance, but mainly if there is something of a duty of care for you to have acted, and you have omitted to act in a serious way. You've omitted to do something. That's when we can see that we can give rise to criminal liability. So given that an omission is a failure to act in a particular circumstance, there is a certain number of instances where a crime cannot be committed by an omission. So for example, robbery, by the very definition of the offence itself, cannot be done through an omission. You cannot admit to do something which then gives rise to you committing robbery. You can't, that can't happen. Okay, robbery requires a positive act. In other cases, though, we can see omissions giving rise to criminal liability. One such example, and a number of key cases in this field, in this particular area of criminal law, relates to the offence of murder. A murder can be committed either by act or by gross omission, okay? Not by just any omission, not just by a failure to act in a particular circumstance, but to fail to act in such a way so as to give rise to criminal liability. So there's something of a relatively high standard, a relatively high bar. Assuming that there is the prerequisite mens rea, of course, attached to these conducts, which is what we are doing for all of these lessons on actus reus. We're just going to assume that we can show mens rea and that there are no defences for the time being while we talk about the acts themselves. A defendant may be liable for murder if they say committed an act which kills the victim. Alternatively, they may be liable if they, intending to kill the victim, leave them in a situation where they will die. So there has to be a certain situation where an individual may die. If there is not this intent, obviously then we can start thinking about the delineation between murder and manslaughter, or even if there is no, even if liability is so far removed that there may not be any kind of criminal conduct at all. But if you intend to kill a victim, you intend to kill an individual, and you create the circumstances, or by failing to act in a way, you create the circumstances where they die, and that was your intention in doing so, in failing to act in a particular way, then you are guilty and can be guilty of murder. A key case in this regard is from the case of Gibbons and Proa from 1918. Ultimately, we have two defendants, so we have a defendant and a party to the crime, D1 and D2. These were both parents. The defendant was the father of the victim, and the second defendant, the secondary defendant, was the stepmother of the victim, such that essentially both D1 and D2, D1 was the parent, an actual father, but the D2 also had de facto parental responsibility, while not necessarily being biologically related to the victim. They still had parental responsibility. The two had both failed deliberately to feed the victim, and then the result of which was that the victim died. So there wasn't an act, there wasn't an attack, for example, or something that physically a positive act that caused the victim to die. There was an omission. There was a failure to feed the victim in such a way as to cause the victim to die. They were both, as you can probably rightly understand, they were both convicted of murder. The result here is that murder can be either an act-based offence or an omission-based offence as well. We'll get on to omissions in more detail in future lessons' time, so don't worry if we haven't covered it to the extent that you think is satisfactory. When we talk about voluntariness and automatism, on the other hand, we have this other issue that we have to deal with, because as mentioned in the previous lesson, the actus reus of an offence must be committed voluntarily, okay? And so if one is acting unconsciously, i.e., and as we mentioned in previous lessons, through muscle spasms, etc., etc., then they cannot be held to have committed the act in question, okay? It has to be done voluntarily, and this gives rise to this question of automatism. And this, in fact, actually negates fully the actus reus of an offence. So rather than thinking about this in a different regard, it is often described as a defence rather than the negation of an offence. And we'll talk about this in more detail in future lessons' time. But one of the capacity defences that exists alongside insanity and intoxication, etc., etc., is this idea of automatism. And we will get to this in more detail in future lessons' time, given the fact that it is often described as a defence. But in reality, we should probably think of it more akin to a negation of actus reus. Okay?